You were attacked in the United States, and now you're scared that speaking to the police could cost you your future here. You scroll survivor forums at 3 a.m., trying to decipher if the U visa is really help or if it's just another dead end. Stay silent, and you could lose work authorization, face deportation, and watch your chances at a green card just disappear. In this video, I'll show you the exact 4-point checklist: substantial harm, useful information, ongoing help, and U.S. jurisdiction, plus the law enforcement form that makes or breaks every single U visa petition. Watch so you can file a rock-solid U visa case, keep your family together, and move from temporary fear to long-term security in the United States. I'm Zaira Solano, founder of Solano Immigration Law Firm, practicing immigration law for 14 years, and you've been the victim of a serious crime in the United States, and there's something that you need to know. The U visa isn't just another immigration benefit. It is specifically designed to protect crime victims who help law enforcement. Congress created this visa through the Victims Trafficking and Violence Protection Act of 2000 because they recognize something important. Victims shouldn't have to choose between their safety and their immigration status. The U visa allows victims of qualifying crimes to remain in the United States temporarily and eventually apply for permanent residence for their green card. But here's what's crucial: this isn't automatic. There are specific requirements you must meet, and understanding these requirements could be all the difference between approval and denial. Let me be clear about something from the start. The U visa process can be complex, and mistakes can have serious consequences. That's why I want to walk you through exactly what you need to know so you can make informed decisions about your case. For a U visa petition to be successful, you must satisfy 4 foundational requirements under the Immigration and Nationality Act, Section 101A, 15U. Think of these as 4 boxes that must all be checked. First, you must have suffered substantial physical or mental harm as a result of being a victim of a qualifying criminal activity. The key word here is substantial. USCIS doesn't expect you to prove the most severe case they've ever seen, but they do need to see that the crime that you suffered had a real meaningful impact on you. This could be physical injuries, but it also includes psychological trauma, depression, anxiety, and other mental health effects. Second, you must have information about the criminal activity. This doesn't mean that you need to know every single detail about what happened, but you need to have some knowledge that would be helpful to law enforcement. Maybe you were the direct victim, or maybe you have information about the perpetrator. The law recognizes that the victim often have the most valuable information for solving these cases. Third, you must have been helpful, are currently being helpful, or are likely to be helpful to law enforcement in the investigation or the prosecution of the crime. This is where many people get confused. You don't need to testify in court, though you might. You don't need to solve the case for the police, but you do need to cooperate with reasonable requests for assistance from law enforcement agencies. Fourth, the criminal activity must have occurred in the United States. This includes crimes that violate federal, state, or local law. So if you were victimized in any U.S. state or territory, this requirement is likely satisfied. The U visa law lists specific qualifying crimes, but here's something important to understand. This list is broader than many people realize. The qualifying crimes include rape, torture, trafficking, incest, domestic violence, sexual assault, abusive sexual contact, prostitution, sexual exploitation, stalking, female genital mutilation, being held hostage, peonage, involuntary servitude, slave trade, kidnapping, abduction, unlawful criminal restraint, false imprisonment, blackmail, extortion, manslaughter, murder, felonious assault, witness tampering, obstruction of justice, perjury, fraud in foreign labor contracting, and solicitation to commit any of the crimes that I just mentioned. But there's more. The law also covers any similar activity where the elements of the crime are substantially similar to the listed offenses. Courts have interpreted this broadly. For example, in cases involving robbery with violence, courts have found that this is substantially similar to felonious assault where there was physical harm to the victim. What's particularly important to understand is that you don't need to have a conviction against the perpetrator for the U visa to be approved. The crime simply needs to have been reported to law enforcement by you or someone else, but the criminal case doesn't need to be resolved. In fact, there doesn't even need to be criminal prosecution in the court system against the perpetrator. I've seen cases where the perpetrator is never found, never charged, or was acquitted, and the U visa was still approved because the victim met all of the requirements. This is often the most challenging part of the U visa process, and it's where having experienced legal representation becomes crucial. You need what's called a Form I-918 Supplement B, which is a certification from a law enforcement agency. The certifying agency can be federal, state, or local law enforcement, prosecutors, judges, or other qualifying government agencies. This includes police departments, sheriff's offices, district attorney's offices, the FBI, immigration enforcement agencies, and even some regulatory agencies depending on the type of crime. Here's what the certification must confirm: that you were a victim of a qualifying criminal activity, that you possess information about the activity, and that you have been, are being, or are likely to be helpful in the investigation or the prosecution of this crime. Getting the certification can be challenging. Some law enforcement agencies are very familiar with U visas and have a streamlined process to review your request for the 918 Supplement B. Others may be hesitant or unfamiliar with the requirements. This is where having an experienced attorney who understands how to work with law enforcement agencies and can explain the benefits of the U visa program becomes invaluable. The certification is valid for the U visa petition, but there's something crucial. The certifying official can withdraw their support if your helpfulness ends. So maintaining cooperation with law enforcement throughout the process of your U visa is essential. USCIS looks at several factors when determining whether you've suffered substantial harm. They consider the nature of the injury, the severity of the perpetrator's conduct, the severity of the harm suffered, the duration of the infliction of the harm, and the extent to which there is permanent or serious harm to the appearance, health, or physical or mental soundness of the victim. This is a totality of the circumstances analysis, and that means that USCIS looks at your entire situation, not just one factor. I've seen cases where someone didn't have severe physical injuries, but suffered significant psychological trauma that qualified as substantial abuse, substantial harm. I've also seen cases where the crime itself might seem less serious, but the impact on the victim's life was substantial and ongoing. Medical records, psychological evaluations, and expert testimony can be crucial evidence in demonstrating substantial abuse. Police reports, photographs of injuries, and witness statements can also support your case. The key is painting a picture of how the crime affected you. The U visa application process begins with filing Form I-918, Petition for U Non-Immigrant Status, along with the law enforcement certification and supporting evidence. There's no filing fee for the principal petitioner, which is important because many U visa applicants are in difficult financial situations. Currently, there's a numerical limit of 10,000 U visas per fiscal year. Unfortunately, demand exceeds this cap, which means there is a long waiting list of people who have pending U visa petitions. If your petition is approved, but a visa isn't immediately available, you'll be placed on a waiting list and may be eligible for deferred action, which provides protection from removal and work authorization. The processing time for U visa petitions has been substantial in recent years, often taking several years. During this waiting period, if you're on the waiting list, you can apply for work authorization and protection from deportation. This interim relief is crucial for many applicants who need to support themselves and their families while waiting for a final decision on their U visa. One of the most important benefits of the U visa is that certain family members can be included in your petition. If you're under 21 years old, you can include your unmarried children under 21 years old, your parents, and your siblings under the age of 18. If you're 21 years or older, you can include your spouse and your unmarried children who are under the age of 21. These family members receive the same immigration benefits that you do, and they can remain in the United States, work legally, and eventually apply for permanent resident status. They don't need to be victims of the crimes themselves, and they don't need their own law enforcement certification. This family unity aspect of the U visa is particularly important because crime often affects entire families, and keeping families together during the healing process serves both humanitarian and law enforcement purposes. After 3 years in U visa status, you may be eligible to apply for permanent residence, and also known as a green card. This is done through adjustment of status using Form I-485. To qualify, you must show your continued physical presence in the United States is justified on humanitarian grounds and to ensure family unity, or is otherwise in the public interest. You also need to show that you haven't unreasonably refused to provide assistance to law enforcement since receiving your U visa. This doesn't mean that you need to be actively helping with ongoing investigations for 3 full years, but if law enforcement makes reasonable requests for assistance, you should cooperate. The path to permanent residence is one of the most valuable aspects of the U visa because it provides long-term security and stability for crime victims who have already been through traumatic experiences. I see certain mistakes repeatedly in U visa cases, and many of these can be prevented with proper guidance. One common mistake is waiting too long to apply. While there's no specific deadline for filing a U visa petition, you generally need to file within a reasonable amount of time after the criminal activity occurred or after the law enforcement need ends. Another mistake is not maintaining contact with the certifying law enforcement agency. If they can't reach you because you changed your phone number or you moved, and if you refuse to cooperate with reasonable requests, they can withdraw their certification, which would severely damage your case. Documentation is also crucial. Many applicants don't gather sufficient evidence to demonstrate substantial abuse or their helpfulness to law enforcement. Medical records, psychological evaluations, police reports, and correspondence with law enforcement should all be preserved and saved, and include those in the petition when relevant. Finally, many people try to handle U visa cases on their own or with unqualified help. Given the complexity of immigration law and the stakes involved, having qualified legal representation can make the difference between approval and denial. The U visa represents more than just temporary immigration status. It's recognition that crime victims deserve protection and that helping law enforcement benefits everyone. It's a path to stability, work authorization, and eventually permanent residence for you and your qualifying family members. But here's what you need to understand. The U visa process is complex and the stakes are high. Mistakes in the application process can lead to delays, denials, or even removal proceedings. Having experienced legal representation isn't just helpful, it's essential for protecting your rights and maximizing your chances of success. If you think you might qualify for a U visa, don't wait. The sooner you begin the process, the sooner you start building your life, the sooner you can start building your case and working towards the stability and security that you deserve. Now, I know that many of you are thinking, what if the U visa isn't the right fit for your situation? What if you're facing domestic violence but aren't sure about cooperating with law enforcement? That's exactly what we're going to cover in my next video about VAWA, the Violence Against Women's Act. VAWA provides another path to immigration relief for victims of domestic violence, men or women, and understanding how it could be crucial for protecting your case and your family's future. The protections under VAWA are different from the U visa, and knowing which option is right for your situation can make all the difference. I'll see you over there.